case briefs, and so much more. LSData's got what you're looking for.
In 1994, Richard Welge filed a lawsuit against K-Mart, Planters, and Brockway after a jar of Planters peanuts shattered and severely cut his hand. The plaintiff argued that a defect in the manufacturing process had led to the accident, while the defendants insisted that the plaintiff's use of a knife to remove a portion of the label weakened the glass jar and constituted misuse. The district judge ruled in favor of the defendants, stating that Welge failed to eliminate other potential causes of the accident. However, the United States Court of Appeals for the Seventh Circuit reversed and remanded the decision, pointing out that using a knife to remove a label is a common and harmless practice. The court argued that even if it were considered misuse, invited misuse is not a defense. The legal rule in question suggests that if an accident is entirely due to a defect in a product, and it is very unlikely that the accident would happen if nobody was negligent, then that accident alone can be enough evidence to prove that the product was defective when it was sold. The court concluded that the narrow holding of Rumley, a previous case, was likely incorrect, given earlier and later cases involving defective bottles and containers.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.